Be agreed to. I call the Honourable Member Andrew Little.
Thank you, Mr. Speaker. I'm glad that my name isn't shortened because you'd probably give me the longer version. But, Mr. Speaker, that aside, this is a serious matter, and we, of course, naturally will support any measure that is going to assist, yet again, to tame the more anarchic and wilder elements of the internet and the world of digital communication. So, and more so where it is used to offend against children and young people. So, Mr. Speaker, we don't challenge the reason and the underlying purpose of this bill, and so we will support it because we think it is worthy of examination by the Select Committee. As the Minister has said, it does a number of things. It removes, for example, the requirement for the Attorney-General to approve the commencement of a prosecution in relation to an objectionable publication. We understand that because those prosecutions have been rising, and we will expect they will become even more prolific simply because of the volume of material that is now being broadcast and communicated through electronic means, smartphones and through the internet and on social media. So, Mr. Speaker, that is worthwhile. We note the increase in penalties and draw the House's attention, and we will draw the Select Committee's attention to the disparity that now seems to be emerging between these objectionable publication type offences and lifting the penalties for that, as against the physical offences against children and young people, particularly when they are sexual offences. And so whereas now the maximum penalty for example, an indecent act on a young person under 16 or meeting a young person following grooming is 7 years, a person who imparts an objectionable publication through, for example, an image on a cell phone, may well be liable to a maximum penalty of 10 years. And yet I would have thought the physical act would have been arguably more harmful and more risky to the young person. So let's examine this legislation to see whether or not there are some basic sentencing and criminal justice principles are applying. The other thing that the bill does is creates a presumption, at least in relation to repeat offences, that the sentence will be one of imprisonment. And indeed it goes as far as to expressly override the Sentencing Act in that regard for the imposition of a sentence of imprisonment where there is a repeat offence under this particular provision. The bill creates the new offence of in relation to indecent communication with a young person under 16. We agree, and as I've indicated in my earlier comments, this is yet another time or another occasion in which this House is having to catch up with the speed with which communication happens now in the modern world and the extent to which young people are connected to it. You don't have to be particularly old now to have your cell phone and to have that as your primary means of communication. Not just a cell phone, of course. Your iPod Touch can be used to communicate through the internet. You don't have to have a phone number. And so this legislation has to keep up with that mode of communication. I know my own son, who is a regular, some would say frequent, I would say continual user of this technology, and we want to make sure, and the legislation should make sure, that there are some rules around it, at least for the benefit of and the protection of young people. So, Mr. Speaker, we think this is well worth looking at and supporting for that examination. I would, however, make the same plea as I made in the parole amendment bill, and that is, can we please have a criminal justice strategy that is coherent and coordinated and that makes overarching sense? And so I look at the Objectionable Publications and Indecency legislation bill, and I wonder whether the harmful digital communications bill that was 6 months in the creation and arrived at the, was introduced into the House in August and had its first reading last week. Or have I got that wrong? It was introduced last week and had its first reading last week. I don't see why aspects of that bill could not be incorporated into this bill, or the other way around, bits of this bill incorporated into that bill. But can we please not have little bits of legislation after little bits of legislation responding to little bits of problems, or actually quite significant problems, but in the overarching overall scheme of things, it is just one problem amongst many. Can we have an overarching strategy? Can we have a Justice Minister focused on a justice strategy, or even a justice strategy for particular parts of the world in which we live? So if it is about the internet and social media and the risk of broadcasting objectionable publications, can we have a strategy to deal with that and deal with all those issues? If it is about making sure that all of the penal provisions in our criminal justice legislation are up to date, reflect the mores of the day, can we have something that deals with that, as opposed to this haphazard, ad hoc sort of approach that the present Minister is taking? That aside, Mr Speaker, this is a legislation well worth the time of this House and examination by the Select Committee, and we will support it and look forward to the debate.
I call Scott Simpson.